Hey, thanks so much for clicking on this video. Today I want to talk about what is family court? Like, what are we even doing here and what is this all about? If you are freshly into a divorce process or you're thinking about separating or your ex is threatening, I'm going to take you to court and I'm going to get the kids, or you're already into the divorce process and you're still confused, this video is for you. I'm just going to break down an overview of exactly what it is we're trying to do in family court and what we can achieve and what we can't and how the process works. And the point of this video is so that you will know an overview of what's going on so that you don't have to spend so much energy and time being confused and being scared. I know a huge part of the trauma that happens in divorce is just the not knowing. And to find out, you can pay your lawyer, you can ask your lawyer and pay them for them to answer you, or you can use up your legal aid hours or whatever. Or you can just click on this video and I'll explain it for you. If you like this content and you find it helpful, you know what to do. Hit like, hit subscribe, hit the notification bell, because I'm super spotty on when I'm publishing new videos because I am a single mom going through a high conflict divorce. So I don't always have time to do these in the way that I would want. But hit the notification bell so that you know when I've published something new. So you're divorcing, you're separating. What is the point of court and divorcing and family law? Basically, when people separate or divorce, they need to make decisions around how to divide things up, support payments, division of assets, and parenting responsibilities, parenting time, and all of that. Most people can agree on most of the things most of the time. The courts are there to help people agree or force an order or a decision upon them if they can't agree, and then so the matter's just settled and final and everybody can move on with their lives. That's the point. So there's a few ways that agreements can happen between the separating parties. The first one is that they just agree, right? So you guys talk about it, you weigh the pros and cons of each option, you come to an agreement. It's an agreement. You can have these legally drafted and then filed with the court, which makes them legally binding. Legally binding means that if one of the parties doesn't adhere to what the order or the agreement says, then the courts may hold them in contempt. Side note about that though, the way you get somebody held in contempt is you take them to court. So I'll get to that later. There's not always a lot of accountability. No one's going to police these agreements or these orders for you. You have to do it yourself, and the only way to get accountability is to go to court, which costs time and or money. So agreements can be made between the two parties. They can happen from lawyer to lawyer. Maybe you're going to be able to settle your divorce by each hiring a lawyer. The lawyers send emails back and forth, and finally you settle and you agree. That's totally a possibility. You could use something called the Family Justice Institute, or it's going to be something similar. Each province, and I don't know about America, I'm assuming that there's a lot of states that would have something similar, is like usually a free government provided kind of mediation center where you and your ex can meet with a professional that will help you tease out the parts of your disagreement and try to come to an agreement. So that's another stage. You could use the Family Justice Center to come to an agreement, or at least come to some agreement, and then you have only a few things to take to court instead of a whole bunch of things. That's an option. Maybe one of you has a lawyer and one of you doesn't. So then it would be one person talking to a lawyer and back and forth. You could come to an agreement through a series of emails or meetings like that. You can come to an agreement using a professional mediator. So unlike the Justice Institute, which is a public, it's like a free service, you could use a private mediator, which charges you to sit down in a room between you and your ex with your lawyers if they're there and just keep you in that room going back and forth until you come to an agreement. That's another way. A further way is to get an arbitration done, and it's not a trial, it's not a court, it's just hiring a lawyer to work as an arbitrator, and they're just gonna take both of your sides, make a decision, and you both agree that that decision is going to be final. That's another way. And then the last way we can get agreements or orders made is through court. So let's look at that now. When we think of court, we usually think of what we see in TV and movies, where it's a trial. It's usually what we see in TV and movies is criminal trials. And so People are showing evidence. There's maybe like a bloodied gun in a Ziploc bag on the counter, or sitting behind the bench, and they're being interrogated or questioned by the opposing counsel's lawyer. That's not at all what happens in family court. So if you're being threatened with court and you're freaking out thinking that's what's going to happen, that's so far down the line, and that's not how it goes anyway. Court works like this. You have to ask the courts or the judge to make an order. So that's what they call, if you can't make an agreement, they're going to make an order, which is a legally binding decision in relation to whatever the matter is. So courts work like this. In some courts, you need to first file a notice of claim, which is fancy legal jargon. It's just basically a paperwork step where you file with the court saying, I'm going to start some shit, okay? Then the second step is to file an application or a motion to get something. So you can't just show up at court and be like, here's my story, blah, blah, blah. What you do is you first notify the court that you're coming, and then you notify the court about what it is you want them to do. You're asking the judge or the courts to make a ruling around selling the house, or spousal support, or financial disclosure, or where the kids are going to live. That's what you're applying for the court to do. That's what you're applying. That's what the motion is about. Okay? Once an application's been filed, the opposing party has to counter. They have to answer that application, or the person applying just gets whatever they want. So your response to the application could be as simple as, I don't agree with any of those things. And then it's going to go to a conference or a hearing or a trial, because you've stated that you don't agree and you're not willing to go along with it. Once there's an application before the courts will try to help parties settle this matter without attending a trial. Everything about the Canadian family law system is about avoiding people going to court. So there's all these speed bumps put in place before you can even get to a trial that you have to jump over to even get there. So there's 3 ways that you can have your matter heard before a judge. And they are conferences, which are the speed bumps I'm talking about that you have to do first before you can get to a trial. So there's conferences, there's hearings or motions, and there's trial. So conferences are informal meetings between you, your ex, your lawyers, if you have them, and a judge. And I'll go over that in a minute. Motions or hearings are like mini trials. They can be 15 minutes, 30 minutes, maybe a few hours, but they're never more than that. Once it's more than a few hours long, then now you're into a trial. But hearings and motions are they're more formal. They're in a courtroom, and all the evidence that's presented is through affidavits. So you're not going to get up and speak in front of a judge or have to tell your story in front of a judge in a hearing or a motion. It's all done through written submissions called affidavits. The last way you can have your matter heard before a judge is a trial. And these are very formal in a courtroom. There's a ton of prep work that has to happen before it. And this is where you may be put on the stand, you may be questioned by opposing counsel, or it's a more complicated process. But trials allow judges much more time to hear the whole story and hear from everybody involved. And because of that, they're very, very expensive. So again, everything in the family law system is avoiding people having to go to trial because it's so expensive in terms of money and time. So if you have a very complicated matter, it's possible that some of the things will be settled in some of the ways, and some of them will be settled in others, and some of them may linger for years. And you can kind of go balls to the wall and say, I want a trial for the whole thing all at once, which would take like a year and a half to get to that stage. More common is this piecing apart of like, okay, let's deal with finances, just emailing back and forth. Okay, we almost did that. We got stuck on one thing. We'll do a little mediation. Okay, we got finances done. Now parenting time. How are we going to do this? Maybe there's maybe you have a conference about it, and you settle some of it in an interim basis, and you decide that the final parenting order is going to wait for a trial a few years down the road, and you're going to get maybe some reports done in the meantime or something like that. You can start any of these processes and be going along with a motion or a hearing or an application or a trial, and then anywhere along the line come to a settlement, come to an agreement with the opposing party, and the whole thing can be turned off. It can be dropped. So all of those are options. I think a lot of time, and certainly what happened to me when I was first being taken through the family court system, there was just so much bullying and threats going on. I really didn't understand my options, and I thought, I was just so afraid. I really felt like, you know, he was going to come after me for 50-50, and we'd have this trial, and it would cost me $200,000, and I would do anything to stop that. But I didn't understand that before this big trial over 50-50, there are dozens and dozens and dozens of steps that can be taken. There's like this little dance you can do where you can get some of the pieces settled and then delay some of the steps, and it can be much more nuanced and full of decisions and options for you than just this like, we're going to trial. So that's what I really want to convey for you. I'm going to create another video about the 3 types of ways that you can be heard before a judge. Again, those are conferences, hearings or motions, and trials. You can't get to a trial unless you've done the other 2 first. So I hope that can settle some of your anxiety. I'm going to do a separate video about those, but what I need to circle back to here is that the whole end game with these exercises, this mediating or going to court or sending emails back and forth, is to get an agreement or a court order. And this is basically a rule book that says this is how you guys are going to act post-divorce. Now, what I need to make sure that you understand is even if you have a really great order or you have a really great agreement, there's nothing that says the other person or you has to abide by those things. If the other party or you is not doing what's in the agreement or in the order, no one is going to do anything about it. No one cares. No one's going to do anything about it. Your only recourse in this case is you would file an application with the court saying that you want the court to find this other person in contempt because they're not following the order. Now, if a judge finds somebody in contempt of a court order or an agreement, they could be fined. There might be jail time. But in reality, if you look through the case law, that's not really the environment. That's not really what's happening in family law these days. So I don't want to make it seem like there's no point to any of this and that you could spend, tens of thousands or hundreds of thousands of dollars getting court orders that your ex might not follow anyway. But that is kind of what I'm saying, because that is what happens. So then what's the point of getting these court orders? I don't know, because sometimes they follow them. I don't know. Does anybody know the point to getting a court order if your ex is very narcissistic? Because they don't follow them. Oh my God. If you have a similar experience where you've spent tons of money getting a court order and your ex just won't follow it, drop it in the comments below. Let's share. It can be really helpful to know that we're not alone in this crazy journey. So thank you so much for sharing your time with me. I really hope that you found this video helpful. And, I'll link to some other videos down below where I'm describing just overviews of the court process. My whole goal here is to just give you enough knowledge so that you don't feel powerless and you don't feel overwhelmed with confusion. This system is mind-bogglingly confusing. And I just know that when you're in trauma and when you're in stress, you don't have access to the parts of your brain that easily allow you to understand things. And so all this information is available on your local government website. But I can't tell you how many times I visited those sites and read it and didn't understand a hot diggity thing. You know what I mean? Like, Sometimes you just need a friendly, warm face to explain things to you in a human way because you're in trauma, you don't have access to your brain. So that's what I'm here to do. Click like, click subscribe, and really share this with someone else that you think it will help, because that's what I'm here doing. I'm just trying to help out. So thank you so much for your time, and thanks for listening. Take good care.